Hi, welcome to the second chapter of the second module of this course, where we shall be discussing the legislative framework on sexual and reproductive health and rights. As we discussed in the previous chapter, sexual and reproductive health and rights is a complex interrelation between health and accompanying rights. Therefore, the framework we will be discussing seeks to capture instruments that govern SRHR in Kenya and internationally. Our starting point and the starting point in most discussions is the Constitution of Kenya 2010, where we have the right to the highest attainable standard of health, which is guaranteed in Article 43(1)(a) of the Constitution. The legislature went further in this article and guaranteed the right to reproductive health inclusive of this right. There was a recognition that reproductive health must be mentioned separately because of its subsidiary status in discourse on health. Additionally, we have the right to emergency treatment. This is in Article 43(2) of the Constitution, whereby every person has the right to access emergency treatment. This and Article 43(1)(a) are bolstered by Article 26(4), which guarantees the right to access an abortion. Drawing from the Constitution, we have a number of national laws and policies that govern health. The Health Act 2017, which was previously mentioned in the first course of this module, discusses the right to health broadly. However, it particularly discusses the right to reproductive health, guaranteeing every man and woman the right to access family planning services and information about their reproductive health. This section goes further and seems to make certain instances of abortion notifiable, which will mean doctors or practitioners will be forced to inform the Ministry of Health or any other government agency when they perform an abortion that falls within the definition given in this Act. Other important legislation includes the Sexual Offences Act. The Sexual Offences Act was enacted in 2006 to curb escalating sexual violence in Kenya. Sexual violence is a direct violation of the right to sexual health and reproductive health. Thus, this act was put in place to ensure that victims of sexual violence could receive justice commensurate to the harm they have suffered. In addition to the Sexual Offences Act, we also have the Prohibition Against Female Genital Mutilation Act. This was put in place to address the practice of FGM, which has severe effects on both the physical and mental health of women. FGM is continuously practiced in many communities in our country, and there's a need to address it and its severe impacts on the right to health. Additionally, and more recently, we have the Protection Against Domestic Violence Act. This act recognizes marital rape as a form of rape, meaning a person in a marriage can be a victim or survivor of sexual violence, and that should be considered when such claims are brought to both practitioners and the court. Finally, in terms of legislation, we have the Children's Act, which was put in place to domesticate the Convention on the Rights of the Child and the African Charter on the Rights and Welfare of the Child. This act is significant because it recognizes a child's right to protection, particularly protection from sexual violence. Further, it recognizes a parent's responsibility to ensure the health and safety of children. We shall now discuss the policy framework on sexual and reproductive health and rights. Firstly, we have the National Reproductive Health Policy, which is aimed at ensuring the reproductive health of all Kenyans by ensuring equitable access to reproductive health services and information. In addition to this, we have the National Guidelines for the Management of Sexual Violence, which guarantee that every survivor of rape, defilement, or incest can access a safe abortion if they so happen to become pregnant as a result of the sexual violence they have faced. Within its policy framework, the government of Kenya recognizes that adolescents who are children or persons aged between 11 and 19 are both sexual and reproductive beings. Therefore, the policy framework around this recognizes adolescents need services and particularly youth-friendly services. To that effect, we have the following policies that govern reproductive health services for adolescents. These are the National Adolescent Sexual and Reproductive Health Policy, the Adolescents Package of Care, and the Guidelines on Provision of Youth-Friendly Services for Adolescents. To finalize this chapter, we look at regional and international law. Article 2(5) of the Constitution recognizes that all treaties and conventions signed or ratified by the Government of Kenya form a part of our law. And these treaties and conventions are significant in developing the normative content on the very important rights we're discussing today. Firstly, we discuss the International Covenant on Economic, Social and Cultural Rights, which was adopted in 1966. Kenya has ratified this covenant and is therefore bound by its provisions. Article 12 of this covenant guarantees the right to the highest attainable standard of health, similar to our Constitution. However, this covenant is important because there is a committee normally referred to as a treaty body that develops normative content on the rights within the covenant. Thus, Article 12 has been fleshed out in General Comment Number 14 on the right to the highest attainable standard of health. In this general comment, the committee stated that for a state, in our case Kenya, to meet its obligation under Article 12, it must ensure that health services are available, acceptable, accessible, and of a certain quality. The committee has gone further and narrowed down this discussion to sexual and reproductive health and rights through General Comment Number 22 on sexual and reproductive health and rights, whereby the committee states that SRHR are dependent or related to civil and political rights, which means that your right to life, your right to liberty, your right to privacy are determinants for your ability to access your sexual and reproductive health and rights. Thus, interdependence and interrelatedness are key themes in this general comment. We also look at the Convention on Elimination of All Forms of Violence Against Women. While this only focuses on the rights of women, it is important for a number of reasons. A number of the general recommendations coming from the CEDAW committee are instructive on how women's health should be addressed, particularly within the context of violence such as FGM. For further reading, you can look at General Recommendation Number 19 on violence against women, General Recommendation Number 24 on women and health, and General Recommendation Number 14 on female genital mutilation. Or finally, with regard to international law, we also look at the Convention on the Rights of the Child, which seeks to govern the rights of children, particularly within the context of sexual and reproductive health. 3 principles are significant when looking at children within this context. First is non-discrimination. Secondly, best interest of the child, and finally, evolving capacities. These principles are thoroughly enunciated in the Convention and should be considered whenever working with children or adolescents. Let us now come back closer to home where we have the African human rights systems. The African Charter guarantees the right to the highest attainable standard of health in Article 16. We also have the Maputo Protocol, which was adopted to govern the political, economic, and social rights of women. The Maputo Protocol is particularly significant for women in Africa because it governs the right to health and reproductive health. Of particular importance is Article 14(2)(c) of this protocol, which guarantees the right to access an abortion in cases of rape, defilement, or incest. It is noteworthy that Kenya ratified the Maputo Protocol with reservation to Article 14(2)(c), the clause on abortion, but this is debatable since Article 26(4) of our Constitution also guarantees the same rights. Thus, the jury is still out on whether or not this reservation is sufficient at this point. Finally, we have the African Charter on the Rights and Welfare of the Child, which mirrors the Convention of the Right of the Child with slight nuances for the African context. This also recognizes principles of non-discrimination, best interest of the child, and evolving capacities. The national, regional, and international policy and legislative framework is by no means an exhaustive list of the laws available for you to study on this chapter. However, please take note of the bibliography in the curriculum that will guide you on other sources that you can consider when reading this.